Hey, everybody, welcome to another episode of the OIG Roundtable. We are one short this week. Matt Kachansky is on much needed PTO for the week. He'll be back next week. So I've got with me my two of the three compadres. I've got Wade McFall or McFowl, depending upon where you are in the country and how you say it, retired assistant special agent in charge from the LA field office, now a manager on our SIU investigative team, and Jaysen retired. Keep saying this, but you're like on chapter three, retired senior executive from HHS OIG, and then the retired Northeast UPIC director and our special director in charge on special projects. And I am still Eric Rubenstein, the senior director of litigation, fraud, waste, and abuse here at Advise. So this week we want to talk about, it was an interesting twist of events that occurred a little bit ago. There was a press release that was put out on the conviction of a provider out of Maryland for essentially upcoding of E&M claims relative to COVID. The provider had been submitting claims at the level 4 office visit in conjunction with COVID testing. And the press release talked about the fact that some of the evidence that was used to convict this provider included some statements that the provider made regarding the fact that these patients were coming in for COVID testing, and there was nothing very technical about the visit. It was fairly straightforward, and he was instructing his staff to kind of just do the basic and then do the COVID test. And so there was a 3-week trial. Provider gets convicted. And I wrote a post on LinkedIn. It got a lot of traction where people were talking about the upcoding issue and some of the things that were in the press release as facts stated. And it led to a bunch of conversations. It was interesting because, level 4 services in the office setting, have to be well documented. And the fact that this provider was indicating that these people were coming in for essentially COVID tests. In some cases, they were asymptomatic. In some cases, they were going for swabs to get a negative COVID test to show that they could return to work, school, or for travel. And for those of you who are keeping up with the things that were going on during the PHE and in the ensuing release of the PHE to the world, there was a lot of what we call surveillance testing, right? People going in for COVID tests for work, school, or travel. And the general feeling was that those weren't going to be reimbursed by insurance. They weren't going to be reimbursed under the HRSA uninsured program because it was part of, the surveillance testing program that was out there. And so the question becomes, do you get to bill for an E&M when the patient is coming in strictly for COVID testing, and even more so when they're coming in strictly for COVID testing when they're asymptomatic? So the provider gets convicted after a 3-week trial, and the provider's attorneys appeal, and it goes to the Court of Appeals, and the Court of Appeals reverses the conviction and relies in what amounts to a 91-page opinion, so obviously substantial, indicating that the government relied upon bad information. The conviction should not have should not stand because E&Ms are subjective and not objective. And so while the E&M has a potential of there being, time or medical decision making, that the courts applied this standard of subjectivity that each one of these can, kind of be seen in its own way. And so it was reversed as a criminal charge. So, there's a whole bunch of things that come out as discussion points. One, should this have been a criminal case? Should this have been a civil case? Should this have been treated as an administrative case? Should this strictly just have been treated as an overpayment? I worked on a bunch of these cases during the kind of coming out of the PHE, where providers were generally billing for level 3 services and were fully documenting them as level 3s. And so are we talking about something that's a 1 level up code? Should this have been a level 1? Where you're just seeing a nurse or some lower level healthcare practitioner take some basic information, do the COVID test, and send them on their way. But it does bring up this one thing that came to mind for me. And Wade, I want to go to you first because it's, you're already spending your day doing your investigation, having to review a policy, having to review a planned contract, right? So from an SIU perspective, you've got to always think about, like, what is the contract between the provider and the plan say? Is there a contract? Is there no contract? Does the contract say that you're going to follow CMS guidance? Does the contract say you're going to follow some plan policy? Does the contract say that you're going to follow a Medicaid policy that's with the state? Is there some nuanced plan? So you're spending part of your day just trying to figure out what's the guidance I have to follow to determine whether or not this is a fraud, waste, abuse issue or not. Now, the added wrinkle, which you and I were talking about before we started our podcast, which is, as an investigator, do you now need to keep abreast of federal case law that comes out, or potentially state case law that comes out regarding something? Do you now need to also think about a medical board decision about a scope of practice issue? Like, at what point does it become enough? But from an investigator's perspective, does this add just another wrinkle into, how your day is not spent investigating things and being a policy related expert?
Yeah, well, I think first off, I think it's close to being impossible to really be able to go back and be, up on all the new case law. There's just not enough hours in the day. I mean, it makes sense to, review press releases and things of that nature to see that some of them that really do matter. But I think it boils down to one of the things we talk to often, and that's that you have to have the experience, kind of the human intelligence to review stuff and make decisions and have discussions. When you're talking about, for example, like, should this have gone civil or criminal, that's, you can't just go by like a flow chart, and if they answered yes to this and no to that, then it's going to be criminal. It's got to have some thought and some discussion. And I think this is another thing that we talked about before we started recording. I think one of the issues in this probably was, and I haven't read the whole case file, just the press releases, but the fact that he made those statements that you alluded to earlier, that they're here for one reason only, that's testing. It's simple and straightforward. We're not here to solve complex issues. But yet he kind of shot himself in the foot, because he also informed his staff to bill at the highest E&M level. So if he would have just told them they're coming in just for straight, testing, and didn't say, I want this billed at a 4, he may not have gotten the conviction, because I got to think that that's what they based it on, as opposed to saying this is a civil case. We have these kind of statements, which is the one thing we're always looking for, and that's intent. So that shows some intent there. So I think that probably, in the investigator's mind, or the whoever's making those decisions, it might have been a AUSA, that brought it from a civil case to the possibility of being a criminal case. So again, I think you have to have discussions on it. You have to have some thought as to the pros and cons of going either way. Obviously, in hindsight, this maybe should have gone civilly. I think the judge even said that it was ambiguous, and subjective rules shouldn't be used for a criminal case. It should be more civil.
Right.
So I think it goes back to the same thing we talk about when we were talking about artificial intelligence and all stuff. You need to have the experience to review it and just kind of think through it and look at the pros and cons, and kind of look as to which direction it should go, I think is what it boils down to.
Yeah, I mean, when we all read that initial press release, I mean, those facts were pretty audacious, right? The statements and billing it at the higher level and all of that. The thing that gives me pause in looking back at the two press releases and all of this other stuff is the fact that it was a 3-week long trial means to me that there's got to be some other nuance there. Because if we're really talking about an instance in which some statements were made and the records didn't reflect that a level 4 was the appropriate code, like, that's not a 3-week trial, right? You pick your jury in a day, you've got opening statements, You put on a couple of witnesses who did the audits and the reviews. You put up some empirical data on the any sampling that was done or payments that were made. Is this provider an outlier? You get a case agent to provide some summary data, and you're in. I mean, this is, to me, it looks like it's a 1 week, maybe, you know, a little bit more than a 1 week trial. So the fact that it went 3 weeks means there's got to be something else there. I didn't get a chance to read the 91-page opinion of the court on the appeal. I'm going to do that. I want to do a little bit more homework on this because it just seems like there's a little bit more of a nuance. But you hit the nail right on the head that, you know, these subjectively interpreted things, and E&Ms, I think, you know, we say it all the time to our clients here, is that an E&M is not an E&M is not an E&M. A gastroenterologist is going to document their E&M very differently than an internal medicine doctor is going to document their E&M. And so you've got to have people that are conversant in that. And it certainly presents itself when you start making these arguments on the subjectivity. And obviously this ruling, while it's only going to be within the, you know, the circuit where District of Maryland is, it certainly has the potential of having more expanded ramifications. So, Jaysen, I want to go to you because, you know, part of this is now from sort of that process piece. And I'll say, like, look, a law enforcement liaison within an SIU is certainly going to be a value for something like this, because when this case is kind of being worked and investigated, and maybe some of these questionable facts are coming out, and, you know, hey, is this really a 1-level upcode? Is it a 3-level upcode? That law enforcement liaison has the ability to have these conversations with the prosecutor on this case or something. But from that, you know, from that policy perspective, from that process improvement in, you know, perspective, does the lack of something, you know, mean that it didn't happen? Or, you know, like everybody says, if it wasn't documented, it didn't happen. But we all know in the healthcare space, it doesn't mean it didn't happen, right? And so the argument is in this subjectivity, like, you know, where do you draw this line of making these decisions? Because these decisions ultimately, right, we talked about the time, effort, and expense to investigate a $2,000 case could be the same effort and time that's required to investigate $1 million case, right? So on a case like this, all that time, effort, and energy to result in a 3-week conviction being overturned, ROI, opportunity cost, all of those factor in.
Well, thank you, Eric. And Weed, you had some really excellent points. So first and foremost, I say that this has to do with resource management from an SIU perspective. So, you know, there's another aspect to this when you're like the OIG, and it has a law enforcement operation, and it has an obligation to protect the program, but to enforce the law. The SIU is about program integrity, and it's a finite amount of resources. Is that the investigation that the SIU wants to spend its resources on? You want sustainable results, having something that just makes, you know, is in the column for a period of time until it gets, you know, rejected or found innocent or whatever else happens. You know, there's no value, no good end to that expenditure of the limited resources. So what Wade said earlier about intent is obviously the key point. So and that would be for either OIG or for an SIU. So is 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 it better to go right to code red and prosecute an individual for you know, a 1-level upcoding, or do you want to work a little bit more and give the person or group or whatever it is a chance to make it right, or to get right with the program, or you're going to again expend those resources just because you think it's the right thing to do? Long and short of it is, you know, it's hard to sometimes keep providers in the networks. You know, they're providing a service to the community. Maybe they're not the best billers. It could be any number of things. I mean, I joked earlier before the call that, you know, you go into the bank and there's no sign in the bank that says you're not permitted to rob the bank. You know, so there, you know, they whether they know the specific nuances of the billing code, well then hire an expert, you know, hire a company like Advise to, consult with you about the ramifications of proper billing and, how to mitigate that risk and things of that nature, that it's all possible and part of a, potentially a good business operation. But getting back to this, could the SIU, could the law enforcement agency be smart about this? Is there an opportunity to allow the provider to do a self audit? Like, hey, here's a concern. This is what it looks like you did and didn't do. And this is and now you're educated. Thank you very much. Put them on a look back list, because if they're doing it a second and third time later, you then have that intent piece that you're really looking for and can make it stick. So I just say that it's not to just say, oh well, it's just not that much, or they only, had $1,000 in the cash drawer at the bank, so it's not that bad. That just doesn't work that way, at least in my mind. So you might have to work a little bit harder to get that situation made right. And then lastly, I just want to ask Wade, who had the look first? The beard and dark glasses and hair. I don't know. It's very interesting.
Following your lead.
All right.
Yeah, it's like looking in the mirror, I'm sure. Yeah, Jaysen, you bring up a good point, which is sort of this self-directed TPE, right? So the targeted probe and education, you send a letter to the provider and say, hey, do a self-audit and let us know what those results are, right? And that's a piece of the puzzle. And we were talking before we did the recording. We worked on a project here recently where the provider got caught up in an Office of Evaluation and Inspection review. OE&I did a study on facet joint injections, and the general feeling was that the general policy was that you can do no more than 5 facet joint injections in a rolling 12-month period for a patient. And this one provider was the subject of one of these studies. It's a strict liability case. He had done more than 5 on many of his patients, and OSIG, Office of Counsel to the Inspector General, sent him a pre-demand letter looking for double damages, and it was a strict liability. Well, while this was going on, CMS went to the MACs and directed the MACs to send letters to all of the providers who had done more than 5 of these, or appeared to have done them, and said, do a self-audit, refund the money, and kind of move on, right? And so, this happens where you kind of say, hey, we see this as a problem. Here at Advise, we did that for years with one of our payer clients. What they would want us to do is when we identified a provider who was an outlier for certain services, it was like send them a letter, kind of like a shot across the bow. Hey, you're an outlier for this, and we're going to give you 3 months or 6 months to recalibrate your billings. If your billings still remain as an outlier, you're going to be the subject, of an audit. So yeah, there's a lot of pieces. So wait, I want to go to you for the last piece of this, because obviously from an investigative perspective, I look at this and I say, well, geez, I've got witnesses who have said these statements, whether they're orally in writing, whatever it may be. He's clearly an outlier on these level 4s, right? From the data, that's probably what got him, caught up in this. And almost, I would say, if I'm an investigator, there's 2 courses of action. One is you do a probe sample of records. You don't have to make this super invasive. You've got witnesses that are saying, this is what he said, right? Clearly, maybe there's emails from it, but we've got statements from people that he said this. I don't think that there was anything that said that it was denied that it was said, but let's say all that is true. You've got a couple of courses. You could look at no medical records whatsoever and just say, just based upon these witness statements, right? That's the super shortcut. You could take the other end of the spectrum, which is to do a statistical sample of records, pull a bunch of records, interview a bunch of beneficiaries and members, go out and do this very intensive investigation. Or you could do something in the middle, which is, get 5 or 10 records, confirm that the things that people were saying are relative to the documentation. Hey, these are all level 4s. Interview a few people. There's like 3 or 4 different ways you can go about doing it. And not to say that any one is right or wrong. A little bit of it is, how much do you want to spin your wheels, right? And this is one of those instances where it could be $1 million, it could be $10. The course of action doesn't necessarily need to differ, right? It's just a matter of what's your thought process and where you get to making that determination. I think if it were me, I would have looked at maybe a handful of records, had them audited, and then made a determination on, where we're going to go. But, what are your thoughts on that?
Yeah, I think I would, and again, this gets back to having somebody with experience kind of walk through it. What are my options? What's going to be the fast track? What's going to be the best option? I don't think I would do a bunch of member interviews on this, just because I feel like in this day and age where most of them are done telephonically, they just don't produce as much as the good old, knock on the door and have a conversation with them. But I think also those interviews are trying to lead up to the types of statements that we have in this case. So I think the statements by the doctor to his staff kind of trumps anything you're going to get from member or beneficiary interviews. So I don't think I would go that route. I would probably do a probe sample just to get an idea of what they were billing. But this is one that I think I don't think you need to spend hundreds of hours on this. I think having those statements is huge. So again, I would just look at a probe sample and I would move forward with that, the piece that you're always looking for, that intent, and build upon those statements. And like you say, hopefully there's emails or some kind of documentation of that. But even if there's not, and you have several employees saying this is what he told us at a meeting, and if he's going to deny it, I think that's it's still pretty powerful. So I wouldn't drag this out for weeks. I would pretty much go with what you have, maybe a quick sample to show kind of the pattern and go from there.
Well, and you bring up a good point about the member interviews. At the end of the day, if there's an allegation that the member didn't get the item or service or procedure, that's one thing. But, what are these people going to tell you? The people are going to say to you, yes, I went to this doctor. I needed a COVID test because I was going back to work, school, travel. I was asymptomatic. I was symptomatic, whatever it may be. They're going to say, yeah, that's what I did. How long did you spend with them? I was there for 10 minutes or whatever it's going to be. They're going to tell you the things that are kind of self-evident from what the nature of the case is. So yeah, there's something to be said about, from an investigative perspective, should you always talk to members and do patient interviews, beneficiary interviews, or should you shortcut that, right? I mean, that's a whole topic for another time, because that's always going to be ad hoc and fact based. So, I'm going to take a read. I want to see the ruling. I want to go into Pacer. I want to look at some of the documents that were put up there. I want to see the indictment, because it is interesting to me when I first read the press release that this guy was where he is after the 3 weeks, and it seemed like from the facts of the press release it was the right decision. But obviously on appeal, some other things may have come out. And kudos to the defense attorneys for attacking the E&Ms as being the issue and the potential of there being this upcoding related matter. So stay tuned. We'll see what happens with that. So, gents, it's winter. Keep warm. Particularly you, Wade. You're in the tundra.
Yeah.
So shovel often, shovel early. It's always good seeing you guys. Again, if you're not getting our newsletter, please sign up for it. The OIG Roundtable is embedded within the newsletter each week, as well as recordings from our previous LinkedIn Lives are up on that. You can get a hold of us at hello@advizehealth.com. Sign up for our newsletter. You can get our podcast on YouTube, on Spotify, a few other services, particularly with YouTube. Go on to YouTube, just search for Advise Health or OIG Roundtable. You'll find all of our prior OIG Roundtables. And again, if anybody has any suggestions for topics or things that you'd like us to provide some opinions or thoughts on, please let us know. And as always, we appreciate the support. And if you are not signed up to meet up with us on LinkedIn, please connect up with any and all of us on LinkedIn, where our content is also deployed. So as always, good seeing you guys. Thanks for tuning in. We'll see you on the next OIG Roundtable.